Hey guys. So twice in one day after being gone for so long. Did you see what hit the docket? Hey Drew, long time no see. All right. So Roses Wild said yes. That means you can hear me? Okay, good. Thanks, Mia. All righty. So this is what hit the docket, and it is so exciting. Normally, I sit and I research and I drive myself crazy looking everything up and get everything just perfect before I go live. But I saw this and I was like, no, I got to do this now. So I haven't had time to get through it all naturally because it's thick, but we're going to do this together. So, what this is, oh, you haven't seen it yet, Christina. Oh, this is amazing. Remember the Vanzan Sham subpoena ordeal that Blake and Ryan used this shell company in order to subpoena the contents of Jennifer Abel's phone that Stephanie Jones extracted from her phone. Then Stephanie Jones took some of that information and shared it with Blake. We know she did it on the very day that she got it because we know from Jennifer what day her phone was taken. And we have a phone call from Leslie Sloan to Melissa Nathan where Leslie Sloan tells her, I've seen the text messages. I'm going to sue you. And that was the start of all of this. So from there, we found out well into this lawsuit that this is how Blake had obtained the information that she put in the New York Times. So the whole thing is very, very sketchy. It's an absolute abusive process, and it has possible there could be criminal actions that arise out of it. As of now, it's just a civil case. But what happened from that is once this was discovered, what company distributed this subpoena, then, of course, Wayfarer's counsel started looking into the legalities of this, how it came about, and it's a big mess. Well, the business itself wasn't properly registered at the time. I don't know all the details about that. I know some of you probably do because some of the content creators really did a deep dive into the actual Vanzan company and they looked up all kinds of things, but I didn't get into it myself. And I know some had said it was a dead company, some said it wasn't. I don't know the truth of all that, so I'm not going to speak on any of that. But I do know that after it was discovered that they brought it up to date and they registered, of all people, they registered Ryan Reynolds as the owner of the company. And I think he thought if he took it on, it would somehow relieve the pressure against Blake. I don't know what he was thinking, though, because as soon as I heard it, and I'm sure the attorneys tried to talk him out of it because they would know better, hopefully, I'm like, this is a crazy idea because it was bad enough if Blake owned the company for her to have used that company for a lawsuit. But if someone unrelated to the movie, like Ryan, used that to subpoena this stuff, and then use that information for this lawsuit, it looks even worse. So this is what he's done to himself now. He's like, well, I'm the CEO of Vanzan, and I don't believe they listed anybody else as having any part of this business. So this is all going to come completely down on Ryan now, which was such a stupid move, but I'm glad he made it because he deserves to be brought into this. He had been dismissed from the case. He stayed in the case long enough. On my subpoena that I got, his name was there. He was one of the people who subpoenaed me, even though he had nothing left to do on the case. Not only that, in the things that they wanted to search any time I had spoken about him, even though he was no longer part of the case. So it was all very strange, but it's like, okay, you want back in the case? You can be back in the case. Here we go. Yes, the raisin, his eyes in this picture. I made them smaller and closer together. It ended up looking kind of cross-eyed because I didn't want to take a lot of time. I just kind of threw it together really quick. But this thumbnail pictures Vanzan. That's just this shell company, just this empty warehouse somewhere that they used. I think the only record of any use that anybody found was she had imported some things from England for a video that she supposedly directed for Taylor Swift. So that's what the inspiration is, just this empty warehouse that nothing happens in, and he's got his own little CEO desk. So let's just go ahead and jump into it now. And when I uploaded this, I think some of these are out of order, but we'll deal with it. It doesn't matter. So it starts off with our absolute darling, Kevin Fritz. So Kevin Fritz says, and I love how he writes, sorry, the squeaky arm of my mic, but I need to lean forward to see the screen a little better. But I love how he treats this as if it's a real company and if it's a serious thing. And like, we don't all know that this is nothing but a big old sham. So it's just hilarious to me to read this very formal wording on this very formal letter when we all know what a sham it is, including Kevin Fritz. So here's what he says. So Wayfarer, what they've done is they have actually scheduled a deposition for Vanzan. That means somebody is going to have to show up and answer the questions. So naturally, nobody wants to do this. Who's going to do it? We don't know. So they've done it because they need to know, as it says, a witness prepared to testify about the full period of its relationship with plaintiff Stephanie Jones and Jones Works. Vanzan is attempting to curtail its testimony to omit information the court has already declared is relevant. They have issued a subpoena to Vanzan, and they asked a bunch of information, and we already knew this because it had come up, they fought before. It was already presented in the court, and the court has recognized that Vanzan is a party to this, not a direct party, but like a third party, non-party to this case that has important information that's relevant. So there's no way around this. It's a subpoena and it's a deposition. You got to show up. And then he mentions the federal rule that says that gives them the right to obtain this discovery. Like I said, it's also formal. It's hilarious. And mentions that the court has already deemed that this is important information. And then it goes into the story about Miss Abel's, in her counterclaims, where she has named Jones. She brought her in as an impleader into the case. And it all goes back to her phone being seized, that the contents were accessed and downloaded. Some of them were disclosed immediately on the date, that's the same date the phone was taken, August 21st, and that she continued to access it. And then right there at the bottom, that these stolen, they outright say stolen because they were stolen communications to Blake and Ryan and Leslie Sloan. That's known. I've had some people come at me on X talking about, well, why hasn't he done anything about Vanzan? It was obviously a no-go or something like that. And I'm like, they are collecting evidence. They have not even begun to deal with it. And now I'm so happy to see this because I've been waiting so I can go back to those people and be like, you asked, so I'm responding. But anyway, Miss Abel also alleges that Blake conspired with Jones parties to obtain her stolen data under the guise of legal process. Miss Lively used her company Vanzan to file a lawsuit in the New York State Supreme Court against Doe defendants, the Vanzan lawsuit. And if you haven't watched, I've done a couple of different episodes about the way that a Doe lawsuit is supposed to go and how this was an absolute abusive process. And it drives me crazy that none of the attorneys that talk about this case have come forward and said it. And it's an abusive process. And this law firm, and not just the attorneys, but the law firm itself, could be kicked off of this case. They could have some serious repercussions for this because, licenses could be lost for this. The purpose of a Doe lawsuit is to find someone's identity. They knew exactly what they were going for. They were going for the contents of Jennifer Abel's phone, and they were getting it through Stephanie Jones. So that's a complete misrepresentation of what a Doe lawsuit is for. And then it just goes downhill from there. So if you haven't seen it, look it up, and maybe later, if I remember, I'll link it in comments so that you can take a look at that to see just how wrong this whole thing was. And I love that they're getting to the bottom of it. So the complaint in the Vanzan lawsuit alleges that the Doe defendants, the identities of whom are unknown to Vanzan, breached unspecified obligations via unspecified oral promises and/or unspecified written agreements. That's impossible if you don't know who this person is. How do you have contracts with obligations with people that you don't know who they are? Yes, karma has entered the chat and the courtroom. Oh my goodness, I'm so excited. Maybe finally mainstream media will pick up the story. And it's wonderful because 2 days from today is the anniversary of Vanzan Sham. See, September 27th. Some of us are planning to all go live together. I want to bake some Vanzan cookies. We're going to have a proper, and we're calling it a harvest celebration because, for one, it's the season of harvest festivals, but also because they harvested her information. I know those two lawyers. That drives me crazy. I wish, you know what? Sometimes, though, here's what happens. Attorneys rely on what they know and they stop looking things up. And so they don't even realize what something is because it's not something they've come across. It's something specialized. Yes, Oktoberfest. So we are going to have Vanzan Sham Day and we are going to celebrate it in full. And this just makes it so much more exciting that we have this just in time for Vanzan Day. Vanzan issued a subpoena therein. So days after demanding the production of documents pertaining to the film, Miss Lively, Mr. Reynolds, and harassment and retaliation in connection with the production of the film, none of which are even remotely referred to in the complaint filed in the Vanzan lawsuit. The Jones parties then handed over Miss Abel's communications to Vanzan. Subsequently, the Vanzan lawsuit was discontinued in December 2024. The same month, Miss Lively included those communications in her pleadings. So she closed it. I think it was the day before she filed the CRD complaint, which was the day before the New York Times article came out. It was all very, very obviously planned. I think they thought it would never see the light of day. I think they thought this lawsuit was never going to come to actual fruition. And then it all did. They kept pursuing it, and it was finally discovered. So here's where we are. In late June 2025, Ms. Abel filed a motion to compel Vanzan to produce certain documents in response to a subpoena. In a memorandum and order dated July 7th, the court properly determined that communications between Vanzan and its counsel and the Jones parties and or their counsel concerning the Vanzan lawsuit are relevant. And we all remember that. That's when we really got excited, and then people were saying, well, nothing came of it. That's because they were still waiting for this subpoena to be answered and the deposition. So once they get those, just watch the sparks fly. The court correctly stated communications between Vanzan and or its counsel and Jones Works and or their counsel concerning the Vanzan lawsuit are likely to bear on or lead to further information regarding whether and when Jones obtained relevant communications and disclosed them to Vanzan or Lively. And then there's a big question about once these were obtained, and if Ryan is the only one on that company, why did Ryan get this information? And then what made him share it with Blake? Every step they take is a big mistake, and I love it for them. So the deposition subpoena commands Vanzan to produce a witness who can testify about enumerated topics, including the ownership and management of Vanzan. And that's one of the things that Vanzan was fighting when it came to just the subpoena. And that's what caused him to have to go and update the business and list someone. And he listed himself as the CEO when all of this happened. They also want to know Vanzan's communication with the Jones party, the extent of the topics numbers 4 and 5, Let's see. Okay, so this was in the back and forth. So they send a subpoena and they list in the subpoena what they want. And then the other side can say this is overbroad. We've got to tailor this a little bit better, narrow it down. So that's what happened. So there was agreement to narrow some topics. They did that, and that was all in Jennifer's counterclaims. So this isn't in the regular docket. This is in the Jones versus Abel that you'll find all of this stuff. So you can find it on Pacer if you look at associated cases, but I think it was Roses Wild said you can just Google court listener Jones versus Abel, and they've got it, and that one's the free one. I don't know if they have them all, but because I get mine from Pacer because they'll have everything that we're allowed to see. Let's see. So the topics were narrowed, but nonetheless, Vanzan is refusing to provide a witness who can testify at a deposition about such communications and the related topics. So they provided some of the information, but they're like, I'm not gonna sit for a deposition. You sit for a deposition. I'm not gonna sit for a deposition. You sit for a deposition. So who is gonna show up to this? Who knows? Maybe they'll send one of their kids. I don't know, but I cannot wait to see who ends up being there. If they're gonna send one of their registered agents or what they're gonna do, but someone is gonna have to show up. And going to have to be someone who can answer all of these questions because you have to answer. Let's see. Lose my place so easy. Vanzan only agrees to produce a witness to testify about what happened after the Vanzan lawsuit was commenced, but not before it was filed. Even though the communications between Vanzan and the Jones parties or their respective representatives concerning the contents of Jennifer Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively is highly relevant. So look at what they're trying to hide. They're trying to, Drew, you're going to sit. Do you have all the answers? Share them with us now. Then we don't have to wait. So they're saying, oh, fine, we'll tell you what happened after because they know nothing happened after the lawsuit. They shut the lawsuit back down. So there's nothing to report about that time. The pertinent stuff is the communication of how this whole subpoena came about in the first place. So how are they refusing? They can't refuse to answer these questions. This is the whole illegal action is how, first of all, the stuff was seized. That's one topic that Stephanie Jones will have to answer for. And the topic concerning Blake and Ryan is how they got this information. Because Stephanie may be able to get away with saying, well, it was a business phone for part of it, not for accessing the cloud. You cannot do that. Not for continuing to access it after Jennifer Abel was long gone. But the sharing it with Blake and Ryan, they basically had stolen information. And this document says that. So this could be possible criminal behavior that Blake and Ryan were involved in. And the law codes that they listed in the document, if you remember me talking about it at the time, this is a civil case, but if it's picked up by the relevant law enforcement agencies and those same law codes are applied in a criminal matter, those contain heavy fines and possible imprisonment. And I think there were two or three federal and one state. So that could mean time spent in federal court and time spent in state court. I mean, not court, prison, federal prison and state prison. I mean, this has the potential to be absolutely huge. Her counterclaims, even though such communications surely occurred before the Vanzan lawsuit was filed on September 27th, Vanzan is refusing to designate a witness prepared to testify about the foregoing. That's what I was just thinking, Fannis. If they send Blake, they might plead the fifth, but they still have to show up. And they're even in a civil trial, you don't usually have the chance to plead the fifth because that's a criminal thing. But when it comes to behavior that is criminal behavior, you can, in a civil case, plead it because it could be something that leads to you getting in trouble. I remember we looked that over before, that you can't plead the fifth in civil unless it is your criminal activity. You don't have to testify against yourself. So, but they're going to have to show up and say that much. It's going to have to be on record. I'm pleading the fifth because this is possible criminal activity, and I don't have to tell that on myself. And that deposition can be used in the civil trial with that statement on there. So there's no way around this. You can't just say, I'm not going to talk about that. You have to show up and you have to plead. So one of their arguments was that this information is obtainable from other sources. But Vanzan is the party who filed the lawsuit. So they are the source. In the court's memorandum and order, one of the few things Lyman got right when it came to this kind of stuff. I love that jail time for the Van Shammers. That's a good one. Roses, is that what you said earlier? Can they just tour Canada until after the date and say you're too busy? No, you got to show up. You got to show up. So the judge already ordered no pro se rule that party sources must be exhausted before documents are subpoenaed from third parties. And who better to answer these questions than the company that filed the lawsuit? Putting aside that no other witness has testified about most of the topics, even if such cumulative testimony existed, the Wayfarer parties are entitled to test what witness to the same events have to say and whether they contradict or corroborate each other. No getting out of it. There is no undue burden imposed upon Vanzan. The corporation has known for months, and certainly since June 2025, when Miss Abel moved to compel its compliance with the document subpoena, that it was in possession of information, material, and relevant to the claims and defenses herein. Furthermore, given the allegations in the counterclaims, the relevant period is not expansive. It's from September to December, very short period of time. And not a lot of things were filed. There was only the summons and complaint were filed, and then it was withdrawn. Those are the only documents. And as far as we know, the only subpoena that was served was the one to Stephanie. So this is definitely not overly burdensome. The Wayfarer parties respectfully request that the court issue an order compelling Vanzan to designate a witness prepared to testify at deposition about the full extent of the relationship between Vanzan and the Jones parties, including the period before the Vanzan lawsuit was filed. In the event the court grants this application after Vanzan's deposition commences on September 30th, the Wayfarer parties respectfully request that the court direct Vanzan to designate an appropriate witness to appear for a deposition consistent with the court's ruling concerning the topics during the first 2 weeks of October 2025. The clock is ticking. All right, let me see. I'm not sure I got these in order, but I don't think it matters to me. Yeah, this is the next one. So this is Kevin's declaration. And we see a lot of really good information in this. So first he identifies himself, tells a little bit of the background, and he talks about this motion to compel Vanzan to designate a witness to testify at deposition, and tells us that the representative has not yet been identified, but that this deposition is scheduled for September 30th, just 5 days away. Well, in 4 minutes, it will only be 4 days away, at 10 a.m. in New York. According to a biannual statement filed with the New York State Department of State Division of Corporations on June 30th, the Chief Executive Officer of Vanzan is Ryan Reynolds. A true copy of that statement is attached. Like I said, he volunteered to do this. Exhibit B are true excerpts from the transcript of the deposition of Blake Lively conducted on July 31st. So these two tales, obviously they asked Blake about this during her deposition, and They're going to compare what's said by whoever represents Vanzan in this deposition to what she said during her deposition. Now, before you get too excited, Exhibit B is sealed. There's just a placeholder in there, so we don't get to read what she said about it. There are only two of those things. The rest of them are all here. So that's what Exhibit B is. It may become unsealed at some point in the future. I don't know, but as of now, it's not available. Then we have a true copy of the complaint, and that's Exhibit C. I think most of you have already seen this. Back when it was first discovered, it was Katie Joy from Without a Crystal Ball that discovered it and reported on it, and she showed the whole thing, and since then it's been widely circulated. So I won't spend time on that one because I think we've all seen it. Then there is a true copy of the subpoena that's issued to Vanzan by Vanzan to Stephanie Jones and Jones Works. And I got so excited when I saw that. Exhibit D is the other one that is sealed. So we still don't get to look at that subpoena. No, I'm not left-handed. I'm right-handed. Let's see. A true copy of a notice of discontinuance filed by Vanzan is Exhibit E. We've all seen that. That's when the lawsuit was closed after they got what they wanted. Then there's a docket which shows that the only two things filed in the whole case was the summons and complaint and then the withdrawal, so that there was no request for judicial intervention and no judge was assigned to the case. And when I saw that, I was so excited because, like I said, I've been the only one that's like sat down and gone through the legalities of how a Doe lawsuit is supposed to go. And a Doe lawsuit is supposed to be brought before a judge. You're supposed to show a prima facie case, which means you show that you have sound legal cause to put the subpoena out there. And the judge is supposed, sorry, I recorded that big thing and my throat's kind of dry. So the judge is supposed to rule on whether or not you presented just cause and then grant the subpoena. But they never asked for a judge to review this case at all. That's important. This is going to be, mark my word, the reason they wanted to know this specifically is because this is abuse of process if you use a Doe lawsuit and you don't have a judge. Okay, then we have, DFJ gets this stuff too. Let's see. According to the docket, oh yeah, that's what we were just talking about. It is a huge deal. Thank you for that. You heard a rumor that Ryan has used Vanzan in other lawsuits. Interesting. I wonder if those are floating around. I'm considering changing my name to Blake's Real Nose, or Blake's Old Nose. Where is it? Blake's Old Nose. Maybe for Vanzan Day especially. Let's see. Then number 10. On September 9th, the Wayfarer parties issued the subpoena to Vanzan, which commanded a representative appear for a deposition and the production of documents. A true copy of the subpoena is attached. And we have that subpoena, but we've all seen that one. Or have we? I think we did when they had the dispute about it, but I'm not sure. But that one's not the big deal. That's not the sham subpoena that we're all dying to see. On September 11th, Vanzan's counsel accepted service of the subpoena. On September 18th, the Wayfarer party's counsel and Vanzan's counsel agreed that the deposition would be held on September 30th. Accordingly, on September 18th, the Wayfarer parties issued an amended subpoena containing the September 30 date for the deposition, and they attached a true copy of that. The topics are as follows. So these are the things that are going to be asked. These are the main things, and of course, there will be side questions depending on the answers that come out of this. Lively's direct or indirect ownership interest in you. And of course, you is Vanzan. ownership interest in you. So besides Ryan and Blake, who has ownership interest? Your managerial structure. This is one of the questions that I just died laughing because, like I said, he's saying this all professional as if this is a real company, and we all know it's not. We know they don't have a managerial structure. The parties' claims, allegations, defenses, and counterclaims in this action. The parties' claims, allegations, defenses, and counterclaims in the action Lively versus Wayfarer Studios. Your relationship and communications with Jones. And this is really important because Stephanie Jones was representing Wayfarer at the time. She was one of the ones that was actually working against Blake and Ryan. And she did things that Wayfarer did not approve of. They had to say, Stephanie, sit down and stop it. We don't want you to do things. They asked her, please don't do anything. And she's went behind their backs and contacted people that she said were her trusted contacts. And they're like, no, we asked you not to do this. Then when Jennifer Abel left the company and Wayfarer followed Jennifer Abel, then they became enemy number one. And the first thing she did was run straight to Blake. So this is what they want to know. What was this relationship? And the communications. When did these communications start? Because what's one of the things we just talked about today about Blake wanting these 47.1 not sanctions, damages, that malice has to be proven. Well, if they can get a hold of these communications and see Blake working with Stephanie Jones and that what she's really worked up about is this stuff, this goes a long way for proving malice or helping to prove malice at least. So the issuance of and communications relating to the subpoena, they want to know whose idea this was, who all talked about it. I still think the New York Times had something to do with this subpoena because Blake very well could have come to the New York Times and said, hey, I have these messages. Look at this. And the New York Times probably said, how'd you get these? Are these legally obtained? We can't print them if they're not. Who knows whose idea it was and what the process was behind getting this subpoena done. And that's what they're trying to get to the bottom of. And I think they're not going to waste their time with Judge Lyman. I think this is going to be a separate lawsuit, hopefully out of California, that they file. I don't know. There's a lot of ways they could go, but it's very exciting whichever way they choose. Yeah, Christy, the New York Times, they got away with murder. They really did. This was awful. Let's see. The claims and allegations in Vanzan Inc. versus Doe's 1-10. Your communications with Blake relating to the subpoena. Because operated by Ryan, that means Ryan got the stuff and would have had to share it with Blake. So they want to know, how did that all come about? There's no way they're going to get to weasel out of this, and this is amazing. Your document collection, document search, and document production in this action. If they have stolen documents, and if it's stuff like access to this woman's cloud and her messaging apps that are not a part of work-related material, that's where these laws, these criminal laws could come into play. Things like wiretapping. We don't know what all this is going to unearth, but it looks like they're going for every single bit of it. So the update is 3 days ago, they met and conferred telephonically with Vanzan's counsel and about its objection to the subpoena, including the topics on which the Wayfarer party seek deposition testimony. Vanzan's counsel claimed that the testimony sought could be obtained from a party. What party? This is directly from you. You need to answer this. When I asked Vanzan's counsel to specify which party, Vanzan's attorney, John Federolf, Esquire, stated that his understanding was that Blake Lively testified about the topics. In response, I asked Vanzan's counsel if they possess a copy of Miss Lively's deposition transcript. But even if she did, like they said, they can get this story from someone else to see if there are any inconsistencies in the story. Been designated confidential under the protective order. Vanzan's other attorney on the call, Margarita O'Donnell, Esquire, answered, "We're not answering that," or similar words to that effect, which is a very good question. This is under seal. How would you have a copy of what she testified to in her deposition? Miss Lively did not testify about Vanzan except for one sentence. Why only one sentence? On the evening of September 24th, 2025, Vanzan served its objections and responses to the subpoena. A true copy of the objections is attached as Exhibit I, and we have that one. In the objections, Vanzan objected to all the topics, alleging that the testimony sought is irrelevant to the claims, defense's facts, or circumstances related to this action. You wish. Furthermore, Vanzan stated that it will only provide information for each of the topics starting from on or about the filing date of the Doe lawsuit. They don't want to show this what led up to that. Sorry, that's the most important part. Subject to that unreasonable limitation, Vanzan stated that it would designate a Rule 30b-6 witness reasonably prepared to testify about non-privileged information. So it sounds like they're planning to send somebody in who has some very limited information. So this is the reason that this is being sent to the court for Daddy Lyman to say, hey, you gotta show this. I don't see how he's going to deny this. How's he going to deny this? He has to. And so this is what they're trying to do to get this motion to compel so that these people understand you have to say this stuff. It's important. It's relevant. Stated differently, even though the communications between Vanzan and the Jones parties or their respective representatives concerning the contents of Jennifer Abel's electronic data seized by the Jones party and subsequently delivered to Blake Lively through Vanzan is highly relevant to Miss Abel's counterclaims against the Jones parties. And even though such communications surely occurred before the Vanzan lawsuit was filed on September 27th, Vanzan has refused to designate a witness prepared to testify about the foregoing. Upon receiving the objections, the Wayfarer parties agreed via email to narrow the topic to Jennifer Abel's counterclaims in this action and the defenses thereto, narrow topic number 5 to Blake Lively's allegation in paragraph 10 of her second amended complaint that she obtained the communications cited in her pleadings. And remember, I've shown this a million times, in connection with a lawful subpoena. That's how she explained. That was the only description she gave about how she got this information. A lawful subpoena. A true copy of an email chain between counsel is attached as Exhibit J, and we have that. Furthermore, and with respect to Vanzan's relevancy-based objection, the Wayfarer parties reminded Vanzan that in its order dated July 7, 2025, the court already determined that discovery from Vanzan was relevant to Jennifer Abel's counterclaims against the Jones parties. Given that the Vanzan deposition is scheduled for September 30th, merely a few days from now, the Wayfarer parties asked Vanzan to withdraw its objections to the topics by noon on September 25th, which was today, and Vanzan has failed to do so. So, let's see how quickly Daddy Lyman rules on this. Oh, wait. Yeah, this is out of order. Let me see. All right. Now we go through these exhibits. So the first one is the objections. So this subpoena was served with the questions that they wanted to know, and these were the objections. Let's see. I don't, this one's really long. It's 36 pages. So I want to kind of go through and find what were the Yeah, this one's kind of long. I'm going to have to do this one on a separate. Yeah, this is way too long. There's no way we can get through 36 pages. We can kind of skim over this real quick, what the topics are. So topic number 1, we already saw that list, the direct or indirect ownership interest that Lively had. They say this is irrelevant and not proportional to the needs of the case, that it's overly broad, vague, ambiguous, and duplicative. How? How is it? It's a simple question. Does she have any ownership interest? How is that overly broad? Topic 2, ownership interest in you. The same objections, irrelevant, not proportioned, overly broad, vague, ambiguous, duplicative. It sounds like this is going to be their canned, their canned answer to all of this. Your managerial structure, the same, look at this. It is word for word, the same answer. How are these questions irrelevant? This is the company that issued a subpoena that got all the information that was the basis of her CRD complaint. It was the basis of the article in the New York Times. It's been the basis of her complaint and both amended complaints since. How is this irrelevant? But it's funny that she's trying it. Topic 4 was the parties' claims, allegations, defenses, and counterclaims. Same answer. Topic 5, the parties' claims, allegations, defenses, and counterclaims in the action, Lively versus Wayfarer Studios. Same. Oh, wait. They've added to this one, besides irrelevant and not proportioned and unduly burdensome, it's also subject to attorney-client privilege and other legal protections, and duplicative. And then they mentioned that Vanzan is a non-party. Sorry, Vanzan, you made yourself a party when you jumped in and filed a lawsuit and served a subpoena. Number 6, your relationship and communications with Jones. They go back to the original answer for the first 4. Your relationship and communications with Jones Works. The same answer again. The issuance of and communications relating to the subpoena. That same answer again. Topic 9 is your claims and allegations in the Vanzan Sham lawsuit. We have the same, now this is the same answer as number 5. This has a lot of the same ones, but also throws in attorney-client privilege. Oh, Samantha Katz. She's the one who filed the Sham lawsuit. She could lose her entire license for this. She could lose her entire career. I hope she got paid enough to retire on. I don't think she's that old, but she could lose everything over this. Number 10, your communications with Lively relating to the subpoena. Irrelevant. Not proportional to the needs of the case. Vague, ambiguous. This is insane. Your document collection, document search, and document production in this action. Let's see. This one's different. They object to this insofar as it suggests that Vanzan had any independent obligation to preserve, collect, search for, and produce documents in this action prior to defendant's service of a subpoena on a non-party. So they object to the relevant time period. So, and of course, then they're going to jump into attorney-client privilege, common interest privilege, and work product doctrine. Now, we just saw Case and Coslow lose badly for things that they were trying to list as attorney-client privilege. Some of those were conversations with one of them's fathers talking about a dog because her father is an attorney, but they said, wait, there was no proof that he was speaking to you in the position of an attorney and not as a father. So we saw them lose. We saw him Judge Lyman be very, very strict about what he allowed to be considered attorney-client privilege. So he better be that strict here too, because these things are absolutely relevant. Okay. Then we have some specific objections and responses. Request number 1, these are the same requests, so her direct ownership and interest. And that kind of repeats. This is where they give like a broader answer. So they say, oh, it's duplicative of number 3, 4, 7. And then they add the same canned answer that they've been giving. Request number 2, let's see what they add to this one. Just kind of the same thing, duplicative, and they list all those other nonsense reasons. Documents reflecting ownership interests. Let's see. Nope, same answer. And then they add that they're a non-party and have no involvement in claims, defenses, or facts or circumstances related to this action. You were the very first action in this whole entire suit. So how you call yourself irrelevant is just laughable. Number 4, documents relating to your managerial structure. May I remind you of the thumbnail? That's the managerial structure. And they use the same canned answer. Documents relating to parties' claims, allegations, defenses, and counterclaims. This one has those little extras in there too about attorney-client privilege. They claim to be a non-party, no involvement. So yeah, they're just gonna just keep repeating and all the way through. Yeah, we've already been through all of these requests anyway, and none of the responses are any different. So we don't need to waste our time on this. And this is the law firm that's representing Vanzan. Okay. So then we had, let's see, which one am I in now? These are kind of all, like I said, they're out of order a little bit. Okay, this was the subpoena that was served on Vanzan. And they always come with all these extra pages, but there are interesting. Here's the list of topics, but we've already been through that in the thing we just reviewed. They're the same ones. And then, of course, it gives the definitions so that they can't say they didn't understand the instructions. We've seen this in these subpoenas. There's always pages and pages and pages. It tells what to do if any of this information has been lost or discarded. It explains how to produce these, what types of file formats are acceptable, that they want the metadata of this information, not just screenshots of it, the message metadata, any attachments. They want it all. And then these requests for production, these are the same ones that we just went through. So, but that gives us an idea of what they're looking for. And if we look at those things, it helps us to see what they're actually after. Have I done this one? Oh, here, I didn't. This is the email one. So I didn't read this one yet in advance. I didn't get that far. So this is just conversations about them asking for someone to appear for the deposition. And this is them agreeing. The bottom one is them agreeing to narrow the topics, which they shouldn't even have to, but they did, which is really super nice. And they're talking about them withdrawing the objections, which we know now that they didn't do. And so they're having to ask the court to compel. They're letting them know we're available for a meet and confer, because they have to do that before they take it to the judge. And then when all else fails, they have to end up going to the judge. And that's what we see has happened here. have I gone through? Yeah, I've gone through everything now. Yeah, so the juicy subpoena, the actual Vanzan Sham legend subpoena is not here, but it looks like they have access to it because they included it. What was the other thing? Oh yeah, the excerpt from her deposition, that wasn't there. Was there one more thing, or were those the only two things? The things I really, really wanted to see were not there. So that's the big news. So the big news is this was not a dead end. This is something that these attorneys are, in fact, going all in to get. Oh, I know what I know what I don't have, because I didn't re-download the summons and complaint. Those are kind of longer things, and I already had those, so I didn't want to pay for them again. Because I got it all off of Pacer. They didn't have all of the when I looked, they didn't have all of the exhibits yet on the free one. So anyway, this is where we are. But I think everybody has seen that. Those are out and available everywhere now. So yeah, it was the summons, it was the complaint, it was the withdrawal, and it was the list that showed that those are the only things that were filed in that whole lawsuit, to show that there was no request for a judge. Deadpool is dead meat. Indeed. Okay. I know the pictures of the tulips. Wait, let's see. That thumbnail is gold. I literally just jumped off your other video and was only thinking about that thumbnail. I know the pictures of the tulips look amazing. I don't, what tulips? Was there? Yeah, it said there was only one sentence from the Blake Lively deposition. I don't know how she got away with only answering that. How did she get away with that? Thank you so much, Eliza. Let's see. Would in that year of tax filing, would it show if Blake claimed any ownership or interest in Van Sham? I would think so. I don't own a lot of companies, so I only have one. So, and I have to show it. But I would assume that if she had ownership interest, it would be. Okay. Thank you, Mr. Lord. Thank you very much. Let's see, what else have I got? I love tulips. They're my favorite flower. Oh, we were talking about flowers on X today. Brian laid a trap for her, and now we're seeing why. And I've been saying so much lately about how clever the Wayfarer Council is, because they're being very, very quiet about their strategy. We have no idea where they're going because they're not out there vomiting it out everywhere like Blake's team is. Blake's team's out there telling everyone we have nothing, and we're deposing and subpoenaing left and right. I mean, the depositions all got left till the last minute because they were so busy subpoenaing 107 content creators, telling the world they have nothing. Meanwhile, Wayfarer has been very, very quiet. They're not out there fighting every day, and they're not giving any of their strategy away. And so now, look at this. Sarah says, I find it so interesting that the lawyer for Vanzan refused to answer if they had seen, yes, Blake's deposition. Sounds like they were shown something under the protective order in order to align stories. And that's a big deal. Blake's team asked for very, very special protection beyond what's usually given. And so for them to be the ones that are going outside these protected orders is really, really crazy. So that other attorney is not involved in this case. They had no right to have access to that. Court listeners going nuts. Can't see anything when I refreshed. It's just been this broke the document, or broke the website. Oh, that's so funny. Blake was the Vanzan CEO at the time of filing. That's what I thought. I thought this stuff originally, but I didn't want to speak on it because, like I said, I wasn't one of the ones that deep dived it because there were enough people doing that. But I thought that it was originally in her name, and then all of a sudden, when it got subpoenaed, Ryan steps forward and claims to be CEO and is the only one put on it, as far as I can recall. Joe just got tulip bulbs. We'll be planting them next week. Oh, yeah, they have to be planted the fall before, don't they? Tulips are so pretty. I love to see them in Amsterdam. Yes, that's what I thought, Lisa. Lisa says that they changed to Ryan in July of this year. That's what I thought, because June is when it came out and hit the docket and got subpoenaed and started being asked all these questions, and then all of a sudden Ryan showed up, and I think he thought that if it was in his name that it would be better somehow. But I disagree with that. Because Blake could have at least said, well, it's my business and I used it for my lawsuit. But what business did Ryan have in there? He didn't have a contract with any of these people. He didn't work with any of these people. The site's probably going to crash, says Tiffany. Yeah, yes. Vanzan Sham just killed court listener. Oh, good morning, Jess. Oh, what does that say? I lost. Yeah, they had more than one location. There was a California and a New York. But the one that served the subpoena was the New York. Okay. Yeah, another clarification. Don't F with Justice says Vanzan Incorporated in California and Vanzan Inc. had no officers at the time of the sham lawsuit. Ryan was CEO day before. Okay, so Blake was the CEO in California, but the one in New York had no officer when they filed this. I thought I remembered people saying that it was defunct at the time, but I don't know if that was true. The Vanzan, Lively was never in the New York Vanzan. Okay, yeah, Don't F with Justice has all this information. Court listener still not working. It broke the internet. You can't be held responsible for testifying against your spouse. But what if it's a company and not you as an individual? I don't know the answer to that question. But if you're speaking as a CEO of a company, you're not speaking as Ryan Reynolds? I don't know. Does anybody know the answer to that? I don't know the answer. That's a good question. Yeah, that's the other thing. The phone that was taken in California from a California resident. Now, it was issued to Jones Works, which does have their headquarters in New York, so I don't know if that was a workaround. But the point is, Vanzan had no right to ask for that information. Irma says that lawyers representing Vanzan Inc. also falsely disclosed to the judge that their articles of incorporation, including directors and officers, are publicly available. The articles of incorporation contain, I'm assuming that's going to continue. Okay. Oh, I see. You guys didn't hear me for a while. I thought so because I couldn't click on the messages anymore. So I figured it had gone silent for a minute. I'm just behind in the messages. Yeah, I don't know that. I think that only matters in criminal court testifying against a spouse. That could be because things like the fifth, certain things are only about criminal. But if it is possible criminal matters, even in a civil case, if it's going to expose your criminal behavior, I think there are still exceptions to that, but I don't know what those are. So I don't want to speak on those, but maybe we can ask, not actually Golden, some of these questions, and hopefully between her and little girl attorney, we'll hear more about that really intricate legal stuff, because they both specialize, well, not in like a Doe lawsuit. Theirs is more special to the harassment claims, but they're so smart. I feel like they know everything. I remember that. Peapod says Elsrich found Vanzan's articles of incorporation, and then days later they changed the status to inactive. Yeah, I think they started to sweat when they realized that it got exposed, and even more when it got subpoenaed. Don't F with Justice says, remember last time court listener responded to me and said it was a DDoS attack, but I think it's this case. Maybe Ryan panicked and hijacked it. he's holding it for ransom. Vanzan is holding it for ransom, so people can't see this. He's like, you got to pay for it. Let's see what happens to Pacer. Well, good news is I saw it and downloaded it before you got a chance to do this. Wouldn't that be funny if he actually did that? You know, people do that kind of stuff. Makes me think of Arrested Development. They can't charge both husband and wife. I love that show. Yes, he thought that that's what they could do. And so he turned the company over to his wife instead of his son. Oh, I love that show. I can't believe she passed away. So even if they make more, but the episodes they made towards the end that were just on Netflix, they got progressively worse and worse. They weren't the same level of funny, even though it was the same people. But I loved that show. I feel like they will use it so they can get away with it. Now we all need to dig into what the law says about this kind of stuff. Oh, really? Missy says that the California Vanzan Incorporated appeared in 2014 federal litigation on the receiving end of a subpoena order. Do you know who subpoenaed them and for what? I never really dove into that because my stuff has more, I usually go through legal documents and they require so much research. I don't have enough time to keep up with those, so I didn't do the side quests into Vanzan. Another reason to dislike Blake and her counsel. Exactly. Blake will try anything. Yes, she will. I hope Blake and Ryan do not find a way out of this. They deserve karma for this mess. You and me both. You and me both. So we'll send up some sacrifices on Vanzan Day for that to come to be. Thank you so much again, Mr. Lord. Cassidy, your thumbnails are brilliant works of art and should end up in the Smithsonian someday with the history of this case. That's one of my favorite parts about making my whole thing. I love making the thumbnails, so thank you for enjoying them. Don't F with Justice, have you done, I imagine you've probably done a whole thing about this, about the Vanzan. If you have, share it with me on X and I will link it in the comments to this. The CIA guy. Yes, he shut down a court listener. Yeah, little girl attorney. She is so good. Really, really like her. I think Ryan's emails and texts would solve all problems, which is why he was dismissed with prejudice. Spouse privilege now, and Blake can say she did not do these things. Yeah, it makes me so very angry that those got dismissed with prejudice before any of this got to come. Because if I remember correctly, Vanzan had been discovered just before Lyman put the motion to dismiss out. And I felt like it was intentional. But I have to go back and check that because that's been a while and so much has happened. I could be remembering it wrong. But yeah, it was ridiculous to dismiss those before they got the chance to get all of this discovery, especially knowing that something was wrong about a subpoena. How do you just close that all up forever? Which is going to make for a great future action, I believe. It could end up being malicious prosecution. So if Wayfarer wins this, even if it's like a summary judgment win, they can file what's called malicious prosecution for this abusive process. And even if they don't win, they can file a separate lawsuit about all of this abusive process. And they might be, I don't know if they're going to try to do it in front of Lyman. They might be sick to death of Lyman and want to do something separate. So we'll see. We'll see where that all goes. Oh, did she? So Lisa says, little girl attorney already posted about this briefly, waiting to get not actually Golden's take as well. Not actually. Golden will probably address it first thing in the morning. She's probably asleep. She usually wakes up early and gets on, and I love it. Love to wake up and she's done it. But little girl attorney is, I believe she's on the West Coast. And so she's in a better time zone for these late night ones. Court listener has been hacked. They knew, and I still think they did it. Peapot says beady-eyed Reynolds and butthole Blake in the picture is sending me. Yeah, she's bringing him dinner. She's bringing him word salad. I don't know if you can read the words, but I've got yummy and playful and never with teeth. And I have dragons and authorship and multitudes, the director in antebellum. That's her word salad. I reused that one because I wanted to hurry up and go live with this, so I didn't want to take a really long time on this thumbnail. Oh, absolutely, Irma. It's hilarious the impact the internet sleuths and online reporters have had on this case. That's for sure. That's for sure. And I bet that's why they subpoenaed us, because they hate us and they wanted to shut us up. They wanted to intimidate us. They thought that it would make us shut up. It just made us more mad. So, but yeah, normally this kind of stuff wouldn't be escaping, because look at what mainstream media is reporting. This whole made up thing about Taylor Swift, that's crazy. And I've heard people say that they knew something big was coming because that Taylor Swift story got released, and it was a big old lie and a bunch of nonsense and got really put out there. It was first put out by Star, a non-reputable company, and then once someone puts it out, all the others can quote from them and not get in trouble, because that's all they have to say is name the source. Oh, this is where it came from, and that takes the heat off of them. So people were saying something big is about to happen that they want to distract from. Now we know what it is. Yeah, Omar hasn't been going live, has he? Hopefully this will get him out there. Missy says Jackson versus Equifax and what the record shows about Vanzan Incorporated. Oh, so this is the rest of that, what you were saying earlier. This is where they showed up in a subpoena? I agree, Rose is wild. I seriously think Ryan would throw Blake under the bus to save himself and would convince Blake to go along with it because it's more important for him to be clean to save them both later. He certainly stands to lose a whole lot more because his reputation, and it was one of my first lives, so it was awful. And I was so nervous. I remember I sweated through my clothes, had to go take a shower when I was done. But so I want to redo it as a recorded one that makes more sense and is put together better than what I was able to do live. But it was called House of Cards, and it was about his success and his money and how it's all wrapped up around his reputation, his ability to be a spokesperson, and that if it falls apart, they lose everything. And that's why I named it House of Cards. So I really need to redo that. And there's some updates. And it's really funny because some of the things I said, was it ESPN? A sports magazine did an article not long after that, and they said some of the exact things that I said, which was so funny to me. So I wanted to update that with their article too. But yeah, he's the one that needs to stay clean, because if he loses his reputation, right now, I don't believe he holds a lot of cash. I think everything is invested. So they're bleeding cash to pay these attorneys. And if his reputation goes down, all of the things that he's invested in for future money, it's going to start to fail. So this could go very badly for him if he loses his reputation. So I absolutely believe that he would do that. Okay, here's Missy continuing. The plaintiff sought to enforce an out-of-district subpoena against Vanzan Incorporated doing business as response makers. So Vanzan was doing business as response makers? Do they have another I wonder how many companies they have. That's what That's what I wondered when we first heard about Vanzan. And they hired the CIA guy, I wondered what they were hiding in how many different shell companies. That was my first question, but I didn't have the time or any means to investigate any of that. No, not Canadian. Very near Canada, though. Yes, the 1-year anniversary. We are going to celebrate it. Don't F with Justice says, I have posts on it. My video was removed from YouTube? What? I knew that some things got taken off of TikTok, but I didn't know that it happened on YouTube as well. Well, I guess I can expect this live to be attacked. We'll see. We'll see what happens. We've been Shapiro. Okay. I agree, Allison. Nothing should be dismissed ever before discovery, unless it's just so absolutely frivolous that there's not even a way to get to any discovery. Oh, thanks. I love Cassidy. She knows her stuff. She's been explaining the Doe lawsuits rules for New York since the beginning, and now it's coming to light. And boy, will I ever feel justified. Okay, I'm getting a little congested. My allergy medicine is wearing off. So I'm going to have to wrap this up. Oh, they were exposed after the dismissal. I couldn't remember. I think they both happened in June, but I don't remember the exact dates. There were a couple of things that were dismissed without prejudice, but I think at that point, with this, some of the bigger things coming to light, they just let that go because they had something else planned. So YouTube said it was cyberbullying. It was public documents. Someone had done that to me back when I covered just Murdaugh stuff. There's a guy who is just absolutely in love with Alex for some reason, and he's written books. And he's a felon himself, and I posted his federal records. Those are public. I paid for them. I got them off of Pacer. And nobody owns, not even the attorneys who file them, nobody owns legal filings. They are public. They are literally owned by the public. And I had the receipts for paying for them. Well, he struck my channel and claimed that it was his written work. And they didn't bother to look at it. And he gave me 2 strikes. So 1 more and I would have been gone. And like, that's it. You can't make a new channel. So I got through and I stayed on and I was like, may I speak to your manager? I was super nice. I was like crying and begging. And you can go against a copyright, but you have to expose yourself. I didn't have my LLC set up yet. And they were telling me, and I said, this man is a stalker. He stalks people that he goes that come up against him. When I reported on him, a bunch of people who have had experiences with him, and lately he's been posting. He's such a racist. A Hispanic woman who is American. He's been posting. On one post he put her city. On another post he put the street name. So if you group it all together, you see it. And talking about sending ICE there just because of her ethnicity. This is the kind of guy he is. Or he will try to get... there was one post he made asking... He put out somebody's IP address and asked people to help him identify it. This is the kind of stuff this man does. I was not about to expose myself to him. And I said to YouTube, I'm like, you're telling me that I either have to put myself in danger or lose my channel, and you will do nothing to help me, even though I'm bringing in more money to you than he is. And she's like, well, I'm not saying that. And I said, but you are, because these are the only 2 options you've given me. I said, I want to fight this, but I don't want to expose myself to this man, because you respond and they get your name and your email address. And I can't remember if they get your address too. They get a lot of your information. And so It went on and on and on. And finally, I'm like, if you will just look at my channel, look at the documents, you will see they are public legal documents. And she's like, well, there was a human inspection of it. And I'm like, there's no way there was, or you would have seen these are public documents that he cannot claim. And then finally I said, there's gotta be somebody else I can talk to. And she said, well, your other option is you can hire an attorney and put the attorney's name and address. And I said, well, let me do that. And I was just like so grateful. I'm like, oh, thank you so much. This is what I'm going to do. And then all of a sudden she turned super, super sweet. And she said, what did she say? She said, I'm going to take a look. And within the hour, my channel those strikes were gone. The videos were put back up. And she sent me a copy of her communications with him lying and saying it was mine, him saying it was his. And she outright said, like, I looked at this was federal documents. This isn't your stuff. And it got put back up. And he continued, because they notified me again later that he was still continuing to fight it, but he wasn't able to win. So you might be able to fight that, but no bathroom burritos. I can see that happening on this video. So we'll wait and see if it's still up tomorrow. But thank you guys so much for joining this late at night. I remember when that happened, Irma, Not Actually Golden's TikTok videos were silenced. They were still up, but you couldn't hear it. It was crazy. And it happened to somebody else on TikTok too. I just hadn't heard that it happened on YouTube, because usually they do pretty good. Cyberbullying is for minors. Jessica Lizzie, thank you, Cassidy. I like to take my allergy meds before I go. Yes, they make me sleepy. All right. Well, everybody have a good night. And thank you so very much. Just a quick thank you again to Eliza and to Mr. Lord. Thank you guys so very much. And let's see what happens tomorrow. 2 days to Vanzan Sham Day.